Good morning, Ms. Furlow. Ma'am, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to be probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you can order for one will be appointed to you, ma'am.
Yes, Judge. Okay. Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated they were in their car and backing out of their driveway when the defendant parked behind them. The defendant then got out of her car and started banging on the complainant's vehicle while shouting obscenities and threats. The defendant also tried to gain entry into the complainant's vehicle. Specifically, the defendant stated she was going to whoop their ass, and the complainant stated they were in fear for their lives during the incident. The officers discovered the defendant is a coworker of one of the complainant's family members.
Owner, boss.
So the threat is what?
The threat is she was banging on the door and said, "I'll whoop your ass."
I have it on camera.
Did you catch that? The judge just ruled there's probable cause, meaning the court believes there's enough evidence for the case to move forward. That doesn't mean she's guilty yet, but banging on someone's car and threatening to whoop their ass on camera? Yeah, not a great look. Do you think this rises to the level of a terroristic threat? Let me know in the comments below.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons, okay? What do you do for a living, ma'am?
I own a fleet company, 3 trucks, and they're my drivers for the road, my OPR drivers.
Okay.
So they just basically stole my vehicles.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, okay?
Okay, but I move out of state next month, so I just talked to my mom.
We'll have you sign a reset, and then we'll just take a seat while we get your bond conditions. We'll have you sign the bond conditions, and then you'll be free to go. Okay, please. Morning, Mr. Singleton.
Good morning, sir. How are you?
Good morning. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So
See, you have the decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but you know, my concern, and I guess my very, very primary concern is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around 200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at 5,002. What did you guys want?
Possibly looking for a PR bond due to the fact that his other 2 cases are extremely high. We believe that he should be able to bond out on that. We have been talks. He has been in talks with some family members regarding possibly coming up with money for the other 2 bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
There's two complaining witnesses on those cases, Judge, and it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with a deadly weapon, Judge, so in the felony cases, there's 2 weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right?
So the state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if possible to do 2,500, that was great.
I don't know, you know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now 2 aggravated assault cases where in one, you point a gun at someone
stated that he would shoot them in the head.
And if I remember, it's something so trivial over, don't talk about the cases though, because I don't want you to,
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No, no.
but, Mr. Singleton,
Not that.
there's a certain way, when someone takes something from you, there's a certain way that you gotta act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you,
Washington?
refresh my memory, because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver in his truck when he was awoken by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back, and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other and was calling out for the second complainant.
Whoa. That escalation went from 0 to machete real fast. Singleton allegedly threatened one person with a gun, then chased another down with a machete and a stick? This is why the judge is losing patience. This isn't just a dispute, it's a public safety hazard. Can you believe this all started over bushes or a fence? Wild.
To come out to the street. So it seems as though he pointed a gun at complainant 1, and then in complainant 2, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, it's just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We'll let you out, and then you pick up these 2 serious cases. You know, if we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a 4th case? We're trying to prevent that from happening, you know?
Understand?
Order in the court.
May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor. But I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with 2 very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can,
My fiance,
you know, but
the person who this is.
you're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes.
sometimes choices are made such that,
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I
You
understand.
got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward, okay?
Yeah,
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front, so we go forward. We don't go backwards. All
yes,
right?
Your Honor.
Okay, all right.
Thank you. Appreciate it.
Stay. Okay? You know, Alan, you know, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, you know, because it's all just anger, right? Yeah.
That's the first time I've seen it actually. Like that, so it makes
It may be worth exploring because it'll help, you know, hopefully upstairs as well. Yeah, thanks. Yes. Mr. He?
Yes, sir.
Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir. Okay. On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn, prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any priority to be honest?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. Do you understand? Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, Your Honor.
I don't think it will, but we have to put you on notice of what we expect and what, you know, what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you very much.
Okay.
Salazar, Your Honor.
Good morning, Mr. Salazar. How are you?
No good. How about yourself?
Friday Eve. So, you know,
Got everything worked the felony out, Judge. He pled guilty to the felon. I believe they reduced it to a lesser included, reduced it to a misdemeanor.
oh, they did.
Yeah, and,
Okay, so it's not a felony. Good.
but they're deported. They've already got the deportation orders in on it.
Really?
Yes, sir. Yeah.
These are things that you got to think about, man. When you're not in this country with permission, you have to think about these things, because when you start acting like a fool out there, they can put you in immigration custody, and then you're stuck like Chuck and then they'll end up, you know, sending you back. What's going to happen now? Is it from Mexico or is it?
Yeah.
Yes, sir.
Yes, sir.
So do you have family there? At least when you get there,
Yes, I do.
okay, well, that's good.
Yeah.
The only thing I'm gonna tell you is that if you want to come back here, do it the right way. You gotta ask for permission first. Don't just come here. Because if you get caught with the feds, you could be looking at serious time in federal custody. Years and years. Don't just come. Do things the right way. And when you do that way in life, good things happen, you know? So what are we doing here?
We're pleading true to the MRP violation, Judge.
In essence, I mean, there's nothing we can really do anyways, because you got the ice hold, so it's,
He has 40 days before they come pick him up.
all right. Did you agreed to voluntary departure? Is that what happened? Yeah, okay. All right, so Mr. Salazar, you were placed on probation for assault of is it a family member, right?
That's correct, Judge.
So there is an affirmative finding.
Yes, sir.
You have to understand that you can never own a gun or ammunition as a result of this. There's an affirmative finding of family violence. So if you ever pick up another one of these cases, you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. A second assault of a family member is a third-degree felony. Do you understand? The other thing you need to understand is that you now have had already a felony reduced to a misdemeanor. The likelihood of them doing that again, it's like lightning striking twice. You understand? Is it true or untrue that you violated your probation?
True.
I will find that it's true. Let's do that on allegation number 15, that he tested positive,
Yes, sir, Your Honor.
not on the
Law violation.
law violation.
Yes, sir.
All right, I'm going to find that is true, Mr. Salazar. I'm going to sentence you to 90 days in jail. I'll give you credit for the 78 days that you've done. Like I said, there's an affirmative finding of family violence. You can never own a gun or ammunition as a result of this. Just be careful, man. You know, if you want to come back, do it the right way. Ask for permission first. All right? Good luck.
Thank you.
Thank you, Mr. Dean.
Yes, sir.
All right. Anderson, tell me about Mr. Anderson.
So there is a bond violation, and
Come up, Mr. Anderson.
however, we worked out a deal with the state,
What?
and to reduce it to a first and then 12 months probation.
Okay.
We have the plea paperwork in your,
Are we doing that now?
if you'll allow us.
Sure.
Okay.
Is this a foregone conclusion that you're going to go into rehab, Mr. Anderson?
Yes, sir.
Because I'm going to tell you now, this is now makes 3 bond violations. The next time you even go next to alcohol, I'm going to put you in a rehab facility.
Yes, sir.
Understand me. I don't care what you're doing. I don't care what it is. You come here kicking and screaming. If I find that you use while you're on this probation, I will amend conditions to put you in a rehab facility. And you could be in there for a very solid year, depending on how well you respond to treatment. You understand?
Yes, sir.
Okay? It's up to you. Do you want to do it? I'm game.
That's his decision.
It's up to him.
Sir.
Okay, done. Do it.
You need to do the.
Are you, I'm sorry, are you ready to go? Okay. Mr. Anderson, you charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement that they're offering you 180 days in jail to be probated for 1 year. As part of the conditions, you will do a DWI repeat offender. It must be a repeat offender DWI education class, okay? 1 victim impact panel, a TRAS to see what other conditions you may need. You must fulfill those conditions while you're on this probation. No breath test refusal. So if you're pulled over in a car and an officer asks you to submit to a breath test, you must take the breath test. No drugs, no alcohol, guardian interlock, 16 hours of community service. Do you have children, Mr. Anderson? What does he have on now? Does he have on a guardian interlock? What does he
He has
have?
a scram right now.
Okay, I'm gonna keep that on for now because I'm suspending his license for a year and I want to make sure that he's not consuming alcohol at all.
So you want him to have the scram and the interlock?
And that's with the franchise, so it'll have to be taken off and then new one will have to be put on from.
Hey, I don't want to take this off until he puts the other one on though.
And Judge, just a reminder, this is a drug. I don't know if that changes your,
That scram device Mr. Anderson's wearing? It detects alcohol through skin, 24/7. And this is his third bond violation. The judge is laying it out clearly: any more alcohol, even NyQuil, could land him in jail or long-term rehab. Do you think he deserves another chance, or is the judge being too lenient here?
No,
Decision.
I have here that he consumed alcohol. So he's still using. I don't care how minute any alcohol that you have, Mr. Anderson. I'm telling you, you consume even a smidgen of alcohol, you will be looking at a motion to revoke that gets filed, and then you will be perhaps and very possibly looking at a rehab facility in the jail. Do you understand? I would like him TRAS'd today. Since he's here today, he gets a TRAS today. And in the TRAS, I wanted to make it known that this is his third bond violation, and that he has a consumption of alcohol 3 days ago, because I want that part of their analysis and how to move forward. So part of what you are agreeing is that you are agreeing to whatever conditions. What conditions are being done by the TRAS. So I don't know what they're going to assess. They may assess intensive outpatient treatment. They may assess supportive outpatient treatment. They may assess something else. Whatever they assess, you must fulfill those conditions. Do you understand? The other thing that you must understand is that even though they're reducing this to a first, and the reason that they are reducing this to a first is to a first DWI is to bypass the mandatory 5 days in jail. That's why this is happening now. But I want you to understand that for the next 70 years of your life, you have all these charges on your record. So if you get pulled over from now on, even the slightest smell of alcohol, you will be in felony court looking at a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand?
Sir.
So I wouldn't even step near a car if you've had something to consume, or if you've had any alcohol whatsoever. Even if you take too much NyQuil, that will cause a loss of the normal use. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? How do you plead to the second offense, DWI, being reduced to a first? Guilty or not guilty?
Guilty. Guilty.
Is it above a 0.15? Is this above a 0.15, Morgan? Do you know?
No, Judge.
Sorry?
No, judges.
No? All right, I will find you guilty. I will send it to you, the agreement. What do you do for a living, sir?
I build valves for oil rigs.
And how much money do you make a month?
About 2 a month, 2,000 a month,
How much do you really make a month?
25,
How much do you really make a month, sir?
2,500.
Order in the court.
I'm not going to assess court costs, but I don't know about assessing the surcharges. That's why I'm asking these questions.
The surcharge shouldn't be assessed on a probation. It's only on a final conviction.
This is a conviction.
It is a conviction, but
It is a conviction.
it's not for DPS. They don't consider it a final conviction because,
It is, though. It absolutely is. We're not doing a deferred.
right, it's a final conviction for the purposes of it being on his record forever, but not for the surcharge.
Okay, so I'm going to take a look at that now. I don't believe that that's the case because I'm going to issue the surcharge on him.
Okay,
Okay? If it's not, I mean, I'll take a look now after it dies down,
okay,
but I don't think that's right. But, and, I mean, you'll be around, right?
yes.
Okay, give me a second. Let me thin out the line and then we'll talk. All right. Take a seat, or I'm going to have you sign all the paperwork.
Yes, sir.
Watch yourself, Mr. Anderson.
Yes, sir.
No tolerance
No, we don't have.
All right, good luck.
It has the open container
Sit down.
There's an open container. That's a minimum of 3 days in jail.
So we're spending on.
Did you want me to abandon the open container?
I'm okay with abandoning it, Judge.
Okay, all right.
Do you remember the one you said yesterday?
So what's going on?
Maybe just-
I'll let you finish off, Your Honor. The defendant ended up calling us back later in the afternoon, but that was after.
Are you guys happy?
Yes, sir.
You want to withdraw it?
Yes, sir, I do.
Done.
Okay, perfect. Thank you.
Okay, for sure.
And Judge, before we're done, there's a companion case that's being dismissed as part of the.
Right, and I see that the gun case will be dismissed. Oh, what about the gun, though? Are you guys forfeiting the weapon?
I believe that was part of the agreement, yes.
Okay, the weapon will be forfeited. All right, it'll be coming.
Do you want him, do you want him to speak with probation?
Yes, please.
Judge, I just had a question. One, does grandma consume the
Correct. Yes.
And then they can sign it.
Is it all right if I text one of our clients? You're about to talk.
Of course. Yeah, of course.
Judge, see my attorney, is it okay if she stands up here with us?
Sure.
Thank you, Judge.
Hi, how are you?
Good. How are you?
Welcome. Who do we have here?
We have Miguel Gonzalez, Your Honor.
Okay. Good morning, Mr. Gonzalez.
Good morning.
Mr. Gonzalez, you were placed on probation for driving while intoxicated. It is now alleged that you have violated that probation, specifically in that, I guess we're not going to go forward on the Berg habit.
Correct. We agreed that we're going forward on the 3 technicals, not the first 2 new law violations.
Okay, I guess to make it easy, we'll just go forward on the failed to perform the community service hours as ordered. Is it true or untrue that you violated your probation?
True, Your Honor.
I will find that as true. I will now revoke your probation, sentence you to 75 days in jail. I will give you credit for the 8 days that you have done. Did I suspend the license?
It wasn't the first time?
Because when they get on probation, normally, unless it's a second, so was this a first?
It was originally filed as a second and pled down to a first.
No, you're saying I didn't?
You did it.
Okay, I have to now. I'm going to suspend your license for 180 days. Mr. Gonzalez, don't drive until you get a license. Otherwise, you get into a car, you're rolling probable cause, man. You understand?
Yes, sir.
Okay, good luck with you.
Thank
All
you,
right,
Judge.
thanks, guys.
May I be excused?
Yes, ma'am. Thanks.